Hello, everyone. Thank you for joining us for the fourth session of So You Thought You Knew Health Privacy. Part 4 of our webinar series is called California Calling: How States Are Closing the Federal Gap in Consumer Healthcare Privacy. Before we dive in to the amazingly interesting topics we're going to be talking to you about today, we're just going to go through a few disclaimers like we've done in every session. Attending and listening to this webinar does not make you a Nelson Hardiman client. The webinar is provided for educational purposes only and is not offered as and should not be relied upon as legal advice. We are going to be pretty California-centric here in this webinar, especially because we're talking about state privacy laws, many of which are led by California. We apologize in advance to non-Californians, but we will be mentioning other state privacy laws up in California, so don't be worried. If you are considering what to do with the information we presented to you today, if you have a specific issue relating to the issues we've presented, please contact an attorney. We at Nelson Hardiman are obviously ready and willing to help, but no obligation to contact us. I'm Adella Katz, and sitting right next to me is our wonderful managing partner, Harry Nelson.
Thanks, Adella. Great to be with everybody today.
So just a brief agenda we're going to be discussing today. Essentially, we're going to be reviewing why there are gaps in healthcare privacy in this country. Why has the federal government failed to fill these gaps, failed to step in the last 20, 30, 50 years? And essentially, how have states come to the rescue to fill in these gaps? What was the inspiration? What was the impetus for states stepping in? What states have enacted comprehensive privacy laws? Have any states created specifically narrow state laws addressing certain types of issues, impacting certain industries? And then we're going to really focus in on the limitations of comprehensive state privacy schemes before turning it over to the really interesting developing universe of class actions against traditional healthcare organizations. Harry?
Great. So I wanted just to say a word before we get started about the question of where are the gaps in privacy related to health in the United States and why this problem wasn't solved at the federal level. If you haven't watched our previous webinars, we encourage you to. What we tried to establish in the first several webinars is first, before HIPAA, you always have to go back and look at the very first health privacy law in the United States. Most people don't know about, called Title 42 CFR Part 2, which was only focused on substance use and shows you what the mindset was in the 1970s, that really health privacy was only an issue in this one highly stigmatized condition of substance use disorder. We talked in our couple webinars ago about HIPAA, and it's very important when we talk about why the states stepped up to think about HIPAA. HIPAA was a landmark, as we said, in 1996, and has continued to be the predominant framework for traditional healthcare organizations that are billing insurance, which is the trigger for one of the main triggers for coverage of HIPAA. And HIPAA, has a framework that it covers, and a lot of this conversation is about what HIPAA doesn't cover, the limits of HIPAA. As we discussed previously, HIPAA is tied to, for jurisdictional purposes, to submitting healthcare claims or transmitting data related to claims for payment, and it doesn't cover healthcare data the way we think of it today. HIPAA was actually, it predated the rise of our current technology environment. It predated the smartphone. It predated all these devices and platforms on which we store our own data as consumers. Our data gets transmitted, our data gets tracked, and it was never really intended to cover those pieces. And candidly, if you look at what's going on in Washington, D.C., it's not the easiest place to get consensus around legislation and fixing HIPAA. So you could say HIPAA was always intended just to be one piece of the puzzle rather than a global solution. And that's an important part of today's conversation. HIPAA, also, as we noted previously, again, just to sort of explain the need for why we needed state consumer privacy laws, HIPAA was deliberately limited in what it sought to do. It did not set standards, right? HIPAA envisioned that larger and smaller organizations might do different things. And ironically, even though we think of HIPAA as setting the requirements, everyone who is trying to comply with HIPAA needs to look to external resources to determine what are the best practices, what are the standards. Those came from government sources like NIST. They come from the CPA world. with things like SOC 2, which is the dominant third-party certification today. And they culminated in this consortium called HITRUST, which began about 15 years ago to really develop standards for best practices in large healthcare organizations. And HIPAA, those are all outside of HIPAA. Those are just some of the examples of the way in which HIPAA really has a narrower focus on the broader set of data sets. And security, what we're going to talk about today, privacy really depends on much more. When you talk to people in the IT world, you'll hear a lot about the CIA triad, which means that when it comes to data, you're really concerned about three things. Number one, C, confidentiality. Is the data protected from outside eyes and misuse? Integrity. Is anyone interfering or potentially altering the data? And number three, availability. Like, do you have constant access to get the data when you need it? Particularly a big issue as we move to the cloud. And we've seen, as we've seen, these are issues that go far beyond part of the reason they're not addressed by standards is they're complex. They involve the interplay between having a process between the personnel in the organization and technology. It's not a simple, pure technology question. It's really a process. So the better way that we would encourage people to think about HIPAA is as establishing a national consistent framework that is the roles, responsibilities, and rules that healthcare providers, healthcare payers, meaning insurance companies and plans, need to follow. Anybody who's in the kind of intermediating between providers and payers, needs to follow this framework. But it's a more limited thing than the broader question of protecting consumer privacy.
Right, and I just want to make a quick comment, as we'll talk about in greater detail later in this webinar. Actually, all of these comprehensive state privacy schemes that have been developed, they all recognize HIPAA actually explicitly in the text of the rules, the regulations, the statutes that have come out. And most of them actually provide specific HIPAA exemptions because they recognize there's very specific information that's covered by HIPAA, that's covered by other narrower medical information state laws, that these types of bigger, sort of outdated, but adapting health privacy laws are covering.
So we want to talk beyond the limits of HIPAA, which is only part of the answer to the question of why these laws came into being. It's very important to talk about the way that technology has changed the game, has changed health privacy. As a result of technology, we store and transmit and handle a much greater amount of data than ever before. Everything that we do online, as we have learned, is trackable. And so all kinds of data is being stored about us. It makes us susceptible to targeted advertising. It allows for algorithmic decision-making. And that may be wonderful for some purposes, right? You might be looking for something, and all of a sudden, anyone who's selling it can see that you're looking for it and start sending you messages. And maybe those are relevant, but they are also invasive of your privacy. And so what we've seen is that technology has really changed the game. It's important to note also that this change in technology has driven consumer demand for more privacy. And we've seen that the United States has suffered in comparison relative to Europe, which took this on quite more seriously. And it's very, very important to today's conversation. And I know you're going to talk about the European law GDPR. And so that's a big part of the equation. And so one part of it that is really interesting to watch that actually came into clarity in the past year, but has been going on for a while, is this kind of what I would call a devil's bargain between healthcare, or not only healthcare, but consumer companies, all kinds of companies that are looking for more customers online, and social media platforms. And what we see is that we as consumers, we voluntarily input all this data, right? We sometimes do that on trackers where we put our own data in, but sometimes we just sign up to be customers and we use services. And those companies naturally say, boy, that's a good looking customer. I wish I could find more lookalikes and more people just like that customer. And so they want to use, they aren't necessarily interested in, they don't think they're selling all our data, but they'll take a little bit of our data, a phone number here, an email there, and they'll share it with a social media platform, maybe Google, maybe Facebook, maybe TikTok, a whole bunch. And they'll say, hey, send us more customers who sort of share traits with this customer. And then what happens though, the reason I say devil's bargain is that the companies on the opposite end then turn around and say, maybe we could sell more stuff to that person, and they start trying to reassemble the person's information. And the scary thing today is that our data is really out there, and they can do a pretty good job of reconstructing you online and figuring out what healthcare you're consuming, what products, what services, and use that. And that is, of course, really invading your privacy. So this came to a head, and attention to this is still playing out very much the subject of lawsuits. But this is really what the third-party transaction looks like. You sometimes hear about it referred to as the pixel. And again, it's happening because we, as consumers, go onto apps and websites and we input our data. And by the way, one of the discoveries, it's not just on web-based companies. We're seeing traditional hospitals and health systems have learned the same trick, right? That's why we have in this graphic image a provider that's a brick and mortar building. Sure enough, lots of health systems are getting customers, putting their information in, saying, hey, we could use a little bit of data about that customer and send that to an ad tech platform to find more people just like that customer. Meanwhile, that ad tech platform is trying to figure out what it can do with the information on the side. And meanwhile, we sort of as consumers are totally unaware as all of our data gets scraped and put together, and our privacy goes out the window.
Definitely. And so I think Harry's presented a really interesting picture about health data specifically, but in general, why states have seen these gaps and are desperately trying to fill the gaps in healthcare privacy that the federal government is just not handling fast enough. In reality, with the emerging growth and the very, very rapid growth of technology, especially all kinds of consumer apps, especially consumer health data apps, collecting an amount of health data and different types of health data that have never really been collected before. As we've mentioned previously, large comprehensive health privacy laws like HIPAA never even anticipated that something like geographic services was even something that was going to be collected, browsing history, IP addresses, et cetera, which, as Harry mentioned, are pieces of information that all of these social media sites, ad tech platforms are collecting to create pictures of consumers. They then will find lookalikes and just kind of invasively market to a group of people that didn't ask for this marketing, and clearly it's all for profit-seeking purposes.
And as we noted on the last webinar, by the way, it's not like the federal government is not attuned to this, right? The FTC has tried to step up and fill the gap, but clearly we can tell from the state action that it just there hasn't been enough federal attention to this problem.
Yeah, and as we'll talk about a little bit later, it's clear that a big reason why states have stepped in is to really help their own residents, their own consumers take back control of their own information, because it's just being taken and collected and shared and sold in such massive waves that we've never seen before. So let's take a step back a little bit. Didn't just magically decide to step in all of a sudden. They did gain inspiration from the European Union's General Data Protection Regulation, the GDPR, which I'm sure everybody's heard about. It was the effective date of the GDPR was May 25th, 2018, which really established the European Union as the leader in privacy in general. It covers a whole host of industries, financial data, health data, all kinds of different consumer data. And it has, according to its own website, the toughest and most comprehensive privacy laws in the world. The really interesting thing about the GDPR that's unlike any kind of US privacy law in the US, is that it actually applies specifically to non-EU businesses that are targeting EU consumers. That's likely a trend we might see in the US in the coming years if the federal government ever does pass a comprehensive privacy scheme. So what does that mean? We've gotten questions in the last 6 months, the last year, from different large clients that are seeking to market or advertise their services to consumers in France and Spain and different countries in the European Union. And these are companies that are based in the US. So if they're marketing any type of services to European consumers, so that means That means even offering translation services on their websites. That means even offering payment in different currencies, right? If the website offers currencies in dollars and euros and pounds, all of a sudden that constitutes targeting or offering services or goods to European consumers. The second a website does that, it's subject to the GDPR, and it is subject to the GDPR's regulations and very, very hefty penalties. So as we'll talk about later, it's really important for organizations, especially larger organizations that are growing, trying to expand their reach, to really be mindful of who they're targeting, how they're targeting, and how they need to protect themselves publicly on their websites. So we'll briefly mention privacy policies later on, but if you're an organization that is targeting European consumers, it's super important to make sure that any kind of privacy policy, terms and conditions, anything that's basically public to the world that anybody can click on your website and see, has to account for US privacy laws as well as European privacy laws under the GDPR.
Just two quick additional comments. We are seeing a challenge for some US companies as they partner, they expand into Europe or joint venture with European companies,
Right.
that there is a culture clash around privacy. And so it's very important for any consumer brand, healthcare company, or others who are trying to do business and with Europeans, that GDPR has really changed the game. And if you're not familiar with their higher standards, it's a big problem. And the other thing I think is important to say is that we don't really see kind of legal understanding of the right to privacy until the early 20th century, right? It's very famously, you see people, I'm going to blank, but it's from law school. I think it was Justice Brandeis on the Supreme Court, but earlier, there was a lot of early 20th century scholarship around all these things like a right to privacy in the first place, a right to not be put in a false light. What we're seeing, I would argue, is the emergence of a whole new articulation of distinct rights in GDPR that are going to be mirrored as we talk about the California Consumer Privacy Act. And Adella's going to get into the details, but I think it's fascinating to look at, for example, the right to be left alone. And I on the ride into work today, I was listening to The Daily, a podcast, and it was talking about artists and writers who now want to know, can they have their data's already been, sucked into AI portals, can they scrape it out? And we are really, my point here is just, we're talking about a whole new level of rights that GDPR began to articulate that are getting carried out through the CCPA. And if AI is any indication, are going to need further development. So this is still an ongoing story about where your privacy rights continue to develop as the digital world develops.
Definitely. Thank you, Harry. And one other quick comment before we move along to state privacy law specifically. Another really important, interesting thing about the GDPR is that it's constantly evolving. Yes, it only became effective 5 years ago, but since that point, we've seen, I'll call it iterations. We've seen at least a few iterations and constant evolution, adapting to technology, which hasn't happened nearly as quickly or as impactfully in the US. So why have states actively stepped in? We've mentioned this before. The active approach seems to be a result of federal inaction, but also a result of the crazy growth in technology we've seen in the last few years. We're a healthcare law firm, so we focus on health data, but consumer apps have come into existence, collecting all kinds of information that we've never seen before. Also, as we've mentioned, these consumer health apps that we've seen in the news earlier this year, right? GoodRx, BetterHelp. They're collecting health information, but they are not collecting health information that's subject to traditional healthcare laws that we're familiar with, like HIPAA, 42 CFR Part 2. So there's this whole host of information. In fact, I read a report the other day that the majority of health data that's collected right now is actually outside of the scope of HIPAA, which is kind of a terrifying fact to understand, which means that other agencies, other legislators, other bodies of law basically have to be created and have to take action to somehow regulate and enforce the regulations of this collection of health data. So we've seen the FTC step in. We've talked about it extensively in our last webinar, and the states obviously have come in to specifically try to protect their own consumers' data that's being collected by these kind of lay companies that are collecting health data specifically.
I also wanted to add one additional thing that's caused the states, I think, to act is a loss of confidence based on data breaches. So the big health data breach, the health privacy data breach that we pay a lot of attention to was Anthem a few years ago.
Yes.
78 million. That wasn't even a big one in the scope of things. You know, we've seen Yahoo had a earlier data breach of close to 1 billion people's information. Equifax 135 million people's information. So massive data breaches, and things like Cambridge Analytica, which was maybe not as many people's information, but really woke people up to the story of how Facebook was able to have you know, all its tracking really misused for political purposes. So so these data breaches have been a big piece of the story of why there's been a real need for you know, for a new sheriff to come in and address this.
And it's great that you're mentioning that, because I think the Anthem breach, correct me if I'm wrong, but I think it was in 2014.
Yeah,
and
I think that's right.
And it still took California, which is the leader, right, of many different types of novel laws, privacy schemes, right? It still took California 4 years to shape up. The CCPA was passed in 2018, but it only became effective in 2020. So basically 6 years since this massive breach. I think Anthem is even headquartered in California, for California to even try to protect its consumers' health data.
It's
So I think
no, it's such a great point. It's crazy. It's crazy that it took this long to wake up to this issue.
Yeah.
And it's a confusing issue. I by the way, I signed on to Google a couple of days ago and I noticed they said your information has been compromised. And it's like there wasn't a notice of the data breach, but what are they telling me I'm supposed to do? I mean, this is really there's really a need for more policing here and faster kind of real-time adaptation. So
yeah, and I think companies themselves, very large organizations, are kind of taking notice of these trends and trying to advertise that they are leaders in healthcare privacy. I've seen like billboards all around town, just from a few weeks back, of Apple taking health privacy in their own hands, kind of thing, you know. So I think people are really stepping up, and yes, it's taken a very long time in the global scheme of things, but I think states, companies, consumers are really shaping up and understanding where the issues lie. So really, this is all about accountability. As we've mentioned, with the rise of direct-to-consumer apps, we needed a shift in regulation, especially as it relates to collection of information online. Really, only in the last 5 years, the number of digital healthcare apps has skyrocketed. I heard a figure a few months ago that something like 90,000 healthcare apps were released in the last couple of years. I mean, that's just a staggering number, not something we can even begin to wrap our heads around. But the amount of information that's being collected and the types of information being collected is something we've never seen before. So like I mentioned, after the enforcement of the GDPR, California also passed first iteration of its state privacy scheme. The CCPA became effective in 2020. The CPRA was passed in 2020, became effective January 1st, 2023, but actually just a week or two ago, enforcement was pushed to 2024. There were new regulations to support and enforce the CPRA that were released at the end of March of this year, but the legislators felt that it was kind of too quick of a turnaround for the July 1st enforcement date, and so it was pushed to 2024, which is, I think, in my opinion, and Harry, you can give me your opinion, but I think it might be a good thing, because companies that were kind of slow to get acquainted with the CCPA, CPRA now have time to really reflect, look back on their practices, and make sure they're ready for enforcement come March of 2024.
No, it's probably, look, I think from a compliance standpoint, it's good to have more time. This was definitely, we've been seeing a lot of anxiety from clients about getting into compliance. There is a lot to do here. By the way, one of the things that interests me, that I think is most fascinating, is the original CCPA back in 2018 only addressed data sales, but what we described a couple minutes ago is what's happening is more of a exchanging data, and CPRA was capturing that for the first time. So I think it's good from the provider side to have more time to get into compliance. From a consumer standpoint, I'm not sure that pushing off, you know, we often see the phenomenon that just because the requirements on the books, if it's not being, isn't enough. If it's not being enforced, then you know, providers, companies can generally take a step back and sort of take it a little bit easier. And I think that's a major shift that at least good news for businesses, that they have more time, not good news for consumers with.
Right. And really only in the last 2 years have other states been following California's lead. 5 other states, so now a total of 6 states have enacted, well, actually, excuse me, 10 states at this point have enacted comprehensive state privacy laws that are going to be enforced through 2026. We have a graphic and a couple slides to show you what those states are. And also 6 other states have active bills in progress. Actually, interestingly, in the last couple of years, about 20 or so states have attempted to pass through some kind of comprehensive state privacy schemes, maybe even more narrow privacy schemes. Those have been shut down. They're currently inactive, but clearly there were many more attempts to follow California's lead and enact comprehensive state privacy schemes.
Oh, by the way, just one important point. I saw one of our colleagues, Tara Davidoff, thank you for pointing this out, noted this was actually a Superior Court decision that pushed off the enforcement of the law, but specifically upheld its validity. So we're living in an environment where the law is being challenged, and the context for this delay was actually a judge's decision. But I appreciate the addition.
Thank you. And we wanted to also mention in the last couple of years, right after the Dobbs decision, and Harry, perhaps you can talk more about this. The state of Washington actually recognized the privacy issues that directly stemmed from the Dobbs decision and the changes that we saw in the entire privacy scheme of this country after the Dobbs decision. And the state of Washington passed the My Health, My Data Act just this year. At the end of April, it's going to become effective next March. But it was the first state to really narrow its scope to target protections to health data, and not just health data in general. It specifically expanded the definition of what we consider sensitive health information. And I'm pretty sure for the first time specifically referenced reproductive health information and abortion-related information that the state of Washington serves to protect. We've never seen that before, and it's really important, like as related to the consequences.
Yeah, no, I'm happy to say just a word about it. So when this whole, I think it's very important to tie this whole wave of state consumer privacy acts to California in 2018. But it's very important when you start talking about this whole issue of where does reproductive health fall into all this. In 2020, so after CCPA was already around, we had this very interesting shift. We had a Supreme Court that had upheld Roe v. Wade and a woman's right to terminate a pregnancy from 1973 for almost 50 years, and then the replacement of Justice Ginsburg on the Supreme Court with Justice Barrett shifted from a court where everyone, the assumption among lawyers and people who watched the court was that Roe v. Wade was sort of safe, into a position where it was seen to be in jeopardy. I do not think it was a mistake that 1 month late after the appointment in January, we saw the beginning of this new FTC enforcement, very focused on reproductive health data, specifically with the FTC action against Flow Health that we spoke about on our last webinar. So, and we've seen that played out in the repeal of Roe v. Wade and this activism by the FTC that very much seems to be tied to a particular threat, even though all health data privacy is an issue. That's a very particular concern, and it's very interesting because I think that also we can see that in why Washington State felt that this was that My Health, My Data was a necessary change, which is getting much more expansive and much more focused than the CCPA here in California, very much ties to that. So this whole question of the right to privacy in the Constitution is not, it shows up in many areas of our law around contraception, around all marriage equality. It's very, very, very interesting point about where the right to privacy protects things in this country. But that was really put to really under strain with the threat and then the reality of the repeal of Roe v. Wade. And I think it's going to continue to play out. We're going to see more states follow definitely Washington's footsteps, because we also don't know, the agenda at the FTC is subject to change from administration to administration. So my belief is that more states are going to take the position of Washington and introduce more expansive, protective, health privacy specific laws.
Yeah, and it was actually interesting that in my head, I'm juxtaposing the federal government's attempt to pass the My Body, My Data Act right around the time that Dobbs was repealed. And obviously that attempt to expand sensitive personal information to include reproductive health information, any kind of abortion related information related to sexuality, gender, etc., that was shut down by the federal government, and Washington state quickly stepped in, passed through this law, which has a very similar name, obviously intentionally, to show that, hey, states are coming in, they're actively taking notice, they're actively taking charge. And Washington state was actually the first state that effectively is able to protect such health data. Obviously, we don't know what the enforcement is going to look like because this issue is so novel, and this type of information has never specifically been protected before. But it's something that's really interesting to watch. And as Harry mentioned, we're definitely predicting that other states are very quickly going to come out and try to protect sensitive information like Washington has. I'm actually a little surprised that California wasn't leading the charge on this one, but Washington state has got it.
Well, two comments. First, we always, while it's wonderful to see greater privacy protection, there's always this question of how these laws work together. So that's a complicated piece to figure out. But also, it's important to note that for anyone who's operating on a national or close to national level, the fact that one state has requirements that Washington state has imposed effectively means that it's easier to have a streamlined approach that meets those standards nationally. So I think we're definitely going to see more states follow suit, but even having one state take that position has implications certainly for national healthcare providers.
Definitely. So let's dive into what kind of specific consumer rights are these state privacy schemes trying to give back to consumers? How are they trying to give consumers back control over their information? Not all states, state privacy laws have all of these same rights, but in general, this is the gist of and kind of the holistic approach that the states are taking. Essentially, right, most importantly, they're giving back consumers the right to access their information, the right to correct, the right to delete their information, the right to opt out of sharing and sales. And specifically what that means, what that really looks like is that consumers are able to send requests in writing. Some states even allow requests over the phone. Usually these state privacy laws require the websites, the businesses that are subject to these state privacy laws to provide specific email addresses and even toll-free telephone numbers for consumers to request these rights, essentially. So what that looks like practically is that a consumer will send an email to this, information@business.com and say, hey, can you please provide me the access to all of the information you've collected for me for the past 6 months? I no longer wish to use your website. Or a lot of times what happens is that a consumer wants to delete their account, let's say with a website. And so they reach out and say, hey, can you delete all of the information that you've collected about me? I don't want to have a trace on your website. So that's what we're seeing practically. And although it probably doesn't happen super often, consumers do have these rights, and businesses that are subject to these comprehensive state privacy laws really need to be on notice that consumers do have these rights, and they need to understand how to properly respond and adhere to these consumer rights. These comprehensive state privacy laws all lay out some kind of deadlines, like response deadlines, respond within 10 days that you're going to take action. And then within 45 days, you have to show them evidence or some kind of proof that you've deleted their information, provide them access to what they're asking for, etc. As Harry mentioned, some states, California leading the charge, have expanded their consumers' right to opt out of not only selling information to third parties and social media sites, for example, but they also now prohibit sharing. So consumers now specifically have the right to say, hey, Facebook, let's say, please don't share any of my information with any of your advertisers. I don't want to receive these ads for these dresses I searched at one time. So that's a new huge right that consumers have very, very recently, in addition to the right to opt out of certain processing with certain service providers, the right to, again, take hold of their information, the right to even opt into sensitive data processing. Not sure why consumers would want to opt into that, but in any case, these are all kinds of rights that consumers now have in their hands. In addition to these consumer individual rights, these state privacy laws also require businesses to shape up and be really transparent. They have to provide very specific notices to consumers upon collection. I'm sure in the last 6 months, the last year, every time you go on kind of a big name website, you see a banner on the bottom of the screen that either says, hey, we're collecting cookies. You can opt in to the collection of cookies. You can limit our collection of cookies. Also, I'm sure you've seen the do not sell or share my information banner. That's for the California folks, which basically lays out information for you as a consumer about what the website is going to collect from you, who it's going to share to, what it's going to do with your information, sell it, share it, etc.
Yeah, I think there are a couple things to add. By the way, if you're dealing with health data, it's important to note, like HIPAA does not include the same expansive set of rights.
Right.
HIPAA does include a right to access your information and to have it corrected. But by the way, if you make a proposal to amend your medical record, the provider also has an obligation to keep adequate and accurate medical records. So they may simply say no, and providers absolutely need to be holding on to medical records. Typically, from a risk management standpoint, you have government agencies that could ask for those records. You have lawsuits that you might need to defend related to those records. So there are a very different set of rights. And as I mentioned earlier, one of the interesting things to see is how this list is going to evolve in an AI world, where, are we, for example, are people going to have the right to have their information once it's scraped into these databases pulled out? Very, very interesting questions ahead.
Is it even possible to scrape all of that? I don't know.
Big questions ahead.
Yeah, I don't know that we understand artificial intelligence or its capabilities at this point enough, how it piecemeals information, how it creates these profiles of people. So we just don't know. We're living in a very, very interesting world. So we wanted to show a couple pictures of the states that very recently in the last couple of years have followed California's suit to create GDPR style protections.
Really interesting, by the way, that list is interesting because it's politically diverse. This is not a red state, blue state issue. There is, we're seeing, and it's fascinating to watch the kind of red state attack on big technology because that it sort of plays into a very different tenor than the reproductive health conversation might have. So there's really a new alignment shaping up around privacy on the political front.
And just from a different perspective, these are the same states that I just showed you on the other slide, but we wanted to show you on a timeline how quickly states have been trying to enact these privacy laws. Clearly, California passed the CCPA in 2018, became effective in 2020, and in 2023 itself, so we're not even finished with the year, but we've seen Virginia, Colorado, Connecticut, Utah, and the CPRA being enacted and become effective. Obviously, we don't know exactly when these laws are going to be enforced. Who knows if their enforcement dates are going to be pushed like the CPRAs. But in general, we've seen this huge and very, very rapid jump by states to follow California's lead. In 2024, we have 3 states coming online, 2025 and 2026. We already have effective dates set. There are 6 other states that have active bills in progress.
And I just think it's fascinating, by the way. We always talk about places where like California and Texas are 2 different worlds. Well, this is one place where they're not. And that should be a powerful statement about how important this issue has become.
Yeah, we just wanted to put it on a map so you could really see the diversity in the states that have already enacted these comprehensive state privacy laws. When we say comprehensive, we are including all kinds of data. We're not limiting it to health data, any kind of financial data, really any kind of data that's collected about consumers online or on any mobile apps. And this is just an image of the states that have active bills in progress, which probably will be enacted and have effective dates set by the end, I'm assuming. So we've talked about how great state privacy laws are, but again, because we're living in a novel world, it's very important, perhaps even more important, to talk about the limitations of these state privacy laws. So there are 3 kind of large buckets here. First of all, state privacy laws are great, but they really only apply to specific types of organizations that meet very specific thresholds. For most of these comprehensive state privacy laws that have been enacted, the only businesses that really have to abide by these regulations and they're even subject to it generally for-profit businesses that meet a certain number of in annual revenue and derive a certain amount of revenue from sharing or selling consumer information. Going back up to the first point, Colorado's privacy law does not specifically exempt nonprofits from applicability, but these states are really trying to exempt state and local government agencies, nonprofits, and institutions of higher education from applicability under these state comprehensive privacy laws. Why? Because states are assuming that these types of entities that are kind of already regulated by the government, that are subject to hefty IRS regulations, perhaps, are not operating with commercial profit-seeking motives like for-profit entities are, and that's perhaps why they exempt these types of entities. What's important to note is that the CCPA and what the CPRA expanded was that if nonprofits in California start acting like for-profit entities, start performing commercial activities, if they partner or enter into joint ventures with any kind of commercial entities, kind of to perform commercial activities, then they will definitely be subject to the CPRA. And although that's not what we're seeing just yet, with the class action lawsuits that Harry's going to jump into later on, we predict that that might be the future of these traditional healthcare organizations, which are nonprofits, these medical centers, which are actually acting and marketing their services using these pixels as technology for profit-seeking motives. Secondly, in addition to the specific entity level exemptions that we just described, there's certain types of data that's actually exempt no matter where it's collected, by whom it's collected. For example, in other state privacy laws, not in California, not under the CPRA, but employee and human resources data are generally exempt from these state privacy laws. In California, businesses that provide information or even applications on their website for job applicants or information for employees actually have to have a specific notice on their website. It can be like in addition to the privacy policy, but it's just a separate notice for job applicants to let them know their rights when they're using these specific websites. So it can get down to that level of nitty-gritty information. In general, de-identified data or data that's publicly available is not really protected. It's not considered personal information or sensitive personal information under these state privacy laws. So that type of information isn't really protected. And third, all of these state privacy laws, as I mentioned earlier, do have some kind of HIPAA exemptions because they recognize essentially that entities that are subject to HIPAA, all kinds of covered entities and their business associates, the information that's collected by them, protect health information or any kind of healthcare records, is taken care of by HIPAA and other state privacy laws like California's Confidentiality of Medical Information Act. But what I did want to mention, and I think Harry, maybe you have some comments about this, we have seen through these interesting lawsuits that Harry's going to talk about that perhaps there's a separation between HIPAA information, like protected health information, and marketing information.
Yeah. So when the CCPA was first enacted, a lot of our clients, healthcare organizations said, "Oh, we don't have to worry about this because we're following HIPAA." And it became very clear that the intent of the law was not to create a second, set of rules for managing health data that is subject to HIPAA, but that marketing activity is not the marketing activity that these organizations were engaging in was absolutely not covered by a HIPAA exemption. And what we're seeing, and we'll talk about the class actions in just a minute, is that in fact, a lot of organizations have this split personality. So I don't want to pick on any particular health systems, although we'll talk about some of the names in just a minute. But there have been a number of organizations, health systems, that have very robust HIPAA management in place for their patient data. They engage in marketing activity that we were talking about earlier, and you go to their website or you get in their database and they're using your information to target. And now we're seeing class actions based on that kind of marketing activity. So there's almost like a kind of, idea that there's a split screen and HIPAA is protecting all of it. And the bottom line is HIPAA is not protecting that outside marketing activity.
So just a few actionable takeaways for any kind of privacy professionals, security officers, privacy officers, even information officers at any organization who's wondering, how do we actually tackle these state privacy laws? This is obviously not a detailed approach. It's obviously not offered as legal advice, but generally speaking, you should really know if your organization is even subject to any of these comprehensive state privacy laws. As we mentioned, there are very specific triggers, specific thresholds that your organization has to meet to even be subject to these comprehensive state privacy laws. So they don't automatically apply to you. Just make sure that you're aware. And in fact, even if you're not subject to these comprehensive privacy laws, it's important to know kind of information and specifically what kind of health data is your organization collecting from consumers. How is it storing it? How is it sharing it? How is it selling it if it's selling it? What is it doing with it? How is it piecemealing it together? You know, what exactly is it doing with it? Sometimes storing information is just as important as collecting it. We want to make sure that any kind of sensitive information your organization is collecting is very adequately stored, encrypted, protected, etc. And in general, make sure to update your website's privacy policies and terms and conditions to make sure that it aligns with the privacy concerns that are coming down the pipeline. If your organization is not subject to comprehensive state privacy laws right now, it might be in the coming future if the thresholds ever change. And finally, make sure to develop and implement mechanisms, external facing and also internally that can adapt to these privacy laws and kind of understand how to respond to consumer requests, get them the data they need, make sure your organization is organized enough to be able to handle any kind of consumer requests that come down the pipeline. Finally, how will state privacy laws be enforced? So far, it's kind of a mishmash. State attorneys general have stepped up and said, hey, we're going to take charge and control enforcement. California so far is the only state we've seen that has come up with an actual established agency, the California Privacy Protection Agency, solely dedicated to privacy regulation and enforcement. We anticipate other states will follow suit in the near future. And also the FTC, as we've said, on the other end of it, from the federal government side, is coming in to kind of fill these other gaps.
One of the lessons we see over and over again, this is beyond privacy and all of compliance, is that it takes time for states to learn their own laws and to decide how to enforce them and to develop blueprints for enforcement activities. So California is clearly out in front on this issue, but as you point out on your slide, the FTC is an example of an agency really waking up and taking this issue seriously. And it's probably going to be a few more years before we see states starts to do the same thing. So we wanted to talk about class actions. And by the way, this is a topic that my view is it's not getting anywhere near enough attention. It has been a really fascinating feature of the changing landscape. And what we began to see that starting last year and continuing with full force around the country is plaintiff class action lawyers waking up to the fact that privacy cases are a big opportunity. By the way, it's fascinating to note HIPAA, when HIPAA was created, there is no private right of action under HIPAA. And in the last decade, we've seen an expansion of state causes of action where sometimes lawyers are grafting HIPAA to state consumer fraud or consumer obligations as a basis to file lawsuits. Here in California, the state law allowed for a $1,000 statutory damage per record, which led to some large judgments. But what we're seeing now is something very, very different. And it is an example of both of health systems and other currently large providers getting sued for the way that they market to consumers and the way that they are using data that we talked about earlier on this in this webinar. So we've seen that, and we listed some of the major institutions that have seen these cases. This trend clearly began in California, like many things, but it has spread across the country, and you can see Midwest lawyers pursuing these. And there is no doubt that around the country, we are going to see more and more class actions, which are really charging, the misuse of data for consumer privacy, consumer marketing in violation of privacy. We're seeing them begin to happen against telehealth companies, and those are going to keep coming downstream. Class action lawyers are going to opportunistically look for targets. Really interesting to look at the theories that they're using. They're using both violations of federal and state laws. Some of the federal laws that we don't always think about as relating to health privacy beyond HIPAA are things like the ECPA, the Electronic Communications Privacy Act, the Stored Communication Act, and other state laws for deliberate interception of data, right? Those are, we're talking about emails and phone numbers most commonly, collection of the data, access, use, maintenance, and all kinds of theories, invasion of privacy under state law, using state wiretapping laws, using state-specific confidentiality laws. This is a massive problem. We are seeing, this is a whole new focal point of legal action, and organizations need to take account of it. We frequently, I think, I don't know if I mentioned on our last, one of our previous webinars, this is sort of a parallel to me of this kind of new kind of claim. We began seeing digital health companies hit with Americans with Disabilities Act claim a few years ago. And then again, those started bigger and bigger and got smaller and smaller. They went from digital companies being accused of not being accessible to blind consumers to brick and mortar healthcare providers, not based on their website, not being accessible and inclusive. So this is a really interesting thing that shifted. We're seeing, it's fascinating that since over the last year, we've seen a true shift where traditional brick and mortar healthcare, hospitals, health systems, academic medical centers that were covered entities are being targeted for the very same thing that companies like BetterHelp and GoodRx are being penalized for violating privacy by disclosing information to social media sites without patient consent. And it's clear this is really a national trend. Plaintiff lawyers are going to use this to target organizations that have multi-state presence. Everybody should be on the healthcare and consumer side of the table, should be really examining class action risk. We often will hear healthcare providers think about a risk in terms of government regulatory action or direct consumer injury, like a classic malpractice case. But this consumer class action, broad consumer cases are a major threat, a major point of exposure. And by the way, first time that Facebook or Meta is being sued directly for the same activity. And every organization should be waking up to it. This is reason to look at your practices, look at your privacy policies, and really start taking action.
And here's just an example of a few cases, just really in the last few months, that have been basically health systems or healthcare companies that were targeted by these class action attorneys, seeking to hold really these traditional healthcare organizations accountable for violating consumers' privacy rights. The claims are essentially the same because they focus on these healthcare organizations taking traditional social media site pixels and embedding them into their websites to basically track consumers' information and share or sell that data with social media sites to, like Harry was mentioning, find consumer lookalikes and bring them more business and more business. We've seen allegations that these healthcare organizations have done so on their actual websites and in their patient apps that were actually password protected accounts that consumers really relied upon the healthcare organization to protect their confidentiality. Clearly, these healthcare organizations are being exposed for conducting commercial activities for marketing purposes, advertising purposes, profit-seeking motives, just like all of those for-profit companies that are subject to these state comprehensive privacy schemes are doing.
Yeah, it does. I have to say, it really feels like a new moment in terms of the plaintiff class action bar, waking up to this massive opportunity. And the question is, who's going to get hit with this and which companies are going to get their houses in order so they're not at risk. And
so far, although we've been seeing that in a couple states, like in California, for example, a very hot cause of action in California for all of these cases is, yes, invasion of privacy and wiretapping, but also the Confidentiality of Medical Information Act, which has been on the books for many, many decades in the state of California. We haven't yet seen cause of action under the CCPA or CPRA in California cases, primarily because a lot of these companies are actually nonprofit entities. But like I mentioned before, they are conducting commercial and kind of profit-seeking activities. So perhaps in the near future, we'll actually see these nonprofits being targeted by these class action suits because they are acting like commercial companies and would be subject to the regulations and rules of the CCPA and CPRA.
And this area, I think we have to say this area is a testament to the creativity of class action lawyers and their ability to find the moment and shifting public attitudes and to be creative in finding sources of law, including very old laws that you wouldn't think have anything to do with this,
Right.
and apply them. And the practical risk calculus has changed. And frankly, from the conversations we're having, we think most companies have not yet woken up to this.
Right. So finally, just a few takeaways. Clearly, comprehensive state privacy schemes and narrowing state privacy laws, like we've seen from the state of Washington, probably going to see many more down the pipeline. All of these privacy laws and schemes are quickly growing to fill the gaps in emerging state privacy issues with the growth of technology that the federal government isn't fast enough or is maybe too divided to tackle. Lay entities and healthcare organizations should definitely be on notice that these state privacy laws exist. They are coming down the pipeline. Many more states are waking up to follow California's lead, and they really need to be prepared to address privacy issues of all kinds and really be able to adapt their websites to these privacy rules and make sure consumers are notified of their rights and be prepared to address any kind of consumer requests in adherence with those rights.
I just wanted to add, I think, part of the reason that we held this webinar and this whole series is because we think our sense from the questions we get and the risks that we see arising are that both healthcare organizations and consumer organizations that are doing anything around health and wellness are really not as in shape as they could be for the way that the landscape has changed. There's just a slow kind of awareness, and we're hoping to accelerate that because it's really time to recognize that there have been significant changes that have already happened and more change afoot, and to adapt. And I'm excited that I hope this was useful. The other thing I want to say we really tried to do in this webinar and the others is not just to give you a checklist of here's what your responsibilities are today. Certainly that's important, but we want to really make sure that strategically you're seeing how the arc is shifting, where the trajectory is, because one takeaway that I hope people have from this webinar and this series is that it's still moving, right? We are describing a massive transformation that is in process, and any organization that wants to address it should not be thinking in terms of what do I need to do today? Yes, you need to ask that question, but you also need to be thinking about the question of where do I need to be in front of this a year from now, 3 years from now, and that's part of what I hope this webinar lets people do.
Thank you, everyone, for joining us today. We have one more webinar in our wonderful series. Can't believe we've already gone through 4. We hope you've enjoyed the content we've provided for you. Our last and final webinar is in a month from now on August 15th. We're going to be wrapping up the series, describing our predictions for the future of healthcare privacy. We hope you'll join us.
We are, by the way, just to we are planning to take the series and some of the feedback that's come up around it, and some of the writing we've been doing, and we're looking forward, hopefully this fall, to be releasing a book that sort of goes even further into depth in this area. And really grateful for the feedback that people have given after these webinars to help us identify what we really need to be addressing.
Definitely. Thank you. And as always, if you have any questions at all, feel free to contact either one of us. Our information is up here on the screen.
There's also, we have a question I see
sure.
that why are these websites outside of HIPAA? Why is all this consumer stuff outside of HIPAA? And so we talked about it a little, but just to address the question, again, we've talked about the limits of HIPAA. HIPAA really defines only covered entities and business associates in relation to their consumer data, into their health data and their use of data for processing health claims. And then one step removed, entities that are supporting and doing work on behalf of covered entities.
Right. And so what are covered entities? Covered entities are traditionally defined under HIPAA as any kind of healthcare provider. So that could be a solo practitioner, that could be your primary physician down the street, that could be a bigger healthcare practice, that could be a hospital. Covered entities are also health insurance companies, healthcare clearinghouses that deal with very specific electronic transactions and basically bill to insurance companies.
And so the question of why are these various websites that we've been talking about in consumer apps?
So they're not considered covered entities because they're not they're not operated by any of the entities or organizations that are traditional covered entities, and they're not.
And even if they're run, what's fascinating is even if you have large health systems, like I'll pick on UCSF, UC San Francisco, even when they are a HIPAA covered entity, they didn't perceive the marketing happening around social media, that wasn't tapping into their electronic health records and just using inbound consumer data collected on their website. They didn't perceive that as being subject to HIPAA, and now we're going to have courts tell us whether that was a safe assumption.
Right.
Thank you so much, everybody. Really great to share the information, and hope it's valuable.
Thank you very much.